I've been to a number of assemblies where Marwan's case has been part of the deliberations, so it is a very high priority within the Inter-Parliamentary Union. They appointed Simon in 2004 to report on the trial. Simon concluded that Barghouti's proceeding failed to meet international fair trial standards, identified multiple breaches of international law, contributed to Barghouti's conviction life sentence. His assessment drew on court documents, in-person observations of the sessions. I just want to say that I've had quite a number of people, including from my own community, I'm Jewish, say that Marwan Barghouti is a terrorist, and that is based upon their reading of the trial. So what Simon's saying here isn't a matter of dry legalese. It is really important for us to make a case in this country internationally about why Marwan Barghouti is a political figure who is fighting for the freedom of his people. And I think that what Simon has to say is really important for us as politicians making that case, but also as public figures. And I feel particular responsibility for that in my own community where views are mixed, shall we say. So over to you, Simon.
Thank you, Alex. Thank you very much to all of you for having me today in London. I need to start with an apology. I can speak English roughly, but French is my mother tongue. So sometimes I need to stop and look for words, try to remember how do you say this in English. Please bear with me if that happens. Yes, as you were saying, the Inter-Parliamentary Union asked me in 2003 to draft a report about the trial. He was arrested in April 2002. The trial, as you can see, there are different steps, ended in September 2003, and that is precisely when the IPU made the decision to send an observer to the trial. But at the time the decision was made, the trial itself had ended. So instead of attending the trial and observing the trial itself, which I could no longer do, and which in any event would have been difficult because I have had the experience of observing trials in Israel and occupied territories, and even with an interpreter, it's always difficult to follow what goes on in Hebrew. I had, I think, a much more interesting opportunity to go to Jerusalem and Tel Aviv in December 2003 to meet with the different actors in the trial, meet with Marwan Barghouti's legal team, to meet with the prosecution's legal team. The Israeli prosecutor was very welcoming. She received me at her offices in Tel Aviv, together with representatives of the Ministries of Foreign Affairs and Justice. They provided me with copies of the proceedings of the trial, which I've had time to have translated and study in depth. What the IPU expected from me was to make an analysis of all this, compared with the standards of what is a fair trial under international law. And that was the basis of this report, which I think is still on the IPU website, which is about 20 pages long, 25 pages long. The conclusions I briefly summarize. The problematic issues of compliance with international laws. Marwan Barghouti was arrested in Ramallah, which is in Zone A, which is under the jurisdiction, according to the Oslo agreements, which is under the jurisdiction of the Palestinian Authority and the Palestinian police and judiciary. He was arrested by the Israeli military forces who entered his house, captured him, and took him to Jerusalem, where he was detained in a prison called the Russian Compound, detained and interrogated. It all starts with how he was arrested, because there are issues under the Oslo agreements. The Oslo agreements were not respected. The Israeli authorities explained that they could not rely on the Palestinian Authority to prosecute people suspect of complicity with terrorism in Palestine, so they had to do the job themselves. This entitled them to go to Ramallah, arrest Barghouti and bring him back to an Israeli prison. This is the first legal issue, the compliance with the Oslo Agreement, and also compliance with the Geneva Conventions. The fourth Geneva Convention has a provision, I think it's Article 49, that says individual or mass forcible transfers from occupied territory to the territory of the occupying power are prohibited. It's pretty straightforward. It doesn't require much imagination to understand. Yet, Israeli Supreme Court, not in the Barghouti case, but a few years back, I think in 1988, construed those provisions as meaning that the authors of the Geneva Convention, which was drafted just after World War II, had in mind mass transfers of people and not individual. And they didn't, at the time when the convention was drafted, they didn't have in mind a situation where the occupying country would be faced with terrorism organized from the occupied territory. So the argument from the Supreme Court was that the Geneva Convention does not prohibit individual arrests, which is a clear contradiction with the Geneva Convention itself, according to international lawyers and specialists. But that is the position of the Israeli authorities. In any event, Oslo Accords and Geneva Conventions are not part of domestic law in Israel. So those issues were raised as preliminary objections during the trial, but the courts did not have a jurisdiction to enforce international law directly in a criminal court of law. So they were not addressed in a direct manner. The next issue is how the investigation went. Marwan was arrested in April 2002, on the 15th of April. He was brought in the evening to the Russian compound in Jerusalem. 3 days later, he was allowed to meet his lawyer on the 18th of April. And after that first meeting, the Israeli authorities issued a decision to forbid any contacts with family, lawyers, any visits were forbidden. A situation of total incommunicado detention, and that lasted for 1 month. During that period of 1 month, that is a period when he was interrogated. So all of his interrogation, including statements allegedly made by him during his interrogation that were relied upon by the court a year later, all of that happened during that incommunicado period when he was not assisted by a lawyer, when he was not entitled to have any visits, and when he met his lawyers for the first time after the interrogation at the end of May, Marwan explained that he was interrogated under torture. The interrogations were in a way that is tolerated by the Israeli Supreme Court, that relies heavily on sleep deprivation during interrogations. Sleep deprivations, which is combined with something called the shabé. The shabé is it's usually regarded as torture, really. It's obliging someone who is, especially in a situation of sleep deprivation, making it impossible for that person to even simply relax. The chair that they are given to rest and to sit down, the chair has nails coming out of the back of the chair, which means you can never lie on the back of the chair. You have to sit on the edge of the chair 4 hours and go through the interrogation. And the interrogation goes together with sleep deprivation, which is tolerated by the Israeli Supreme Court. As I said, international bodies have repeatedly described as a direct violation of the United Nations Convention Against Torture, of which Israel is a party. So he did make these allegations that he was tortured, that he was interrogated under duress, but he also said that he had never confessed to any of the crimes that he was accused of. And it's interesting to insist about this because during this incommunicado detention period, there were leaks in the Israeli press that said that Marwan Barghouti had confessed on organizing terrorist attacks. And those confessions, how did they arrive in the media? How did they arrive to Israeli journalists who published them? He had no communication with anyone. The leaks could only come from the security services themselves. And of course, when I think on the 22nd of May or 21st of May, he had his first private meeting with his lawyers, that was the first question that they asked him when I met them. They told me, did you really confess? And he said, no, never. I never confessed about that. One of the big issues is that the allegations of torture were never investigated, and that the statements obtained from a prisoner without the assistance of a lawyer create a situation which is incompatible with international standards. The fair trial standards are mainly set down in the ICCPR, the International Covenant on Civil and Political Rights. That is an international treaty set up by the United Nations that entered into force in 1976, if my memory is right. And the ICCPR sets up a specific committee, the Human Rights Committee of the United Nations, which is entitled to shed light on the provisions of the covenant and interpret the provisions of the covenant. And under those provisions and the interpretation of that committee, interrogating a suspect without the assistance of a lawyer, delaying the appearance of the suspect before a judge, torturing the suspect. All of this makes statements obtained from that suspect, how do you say that in English, irrecevable, inadmissible? Yes, I think we should perhaps turn to the fair trial rights. Thank you, Alex. Inadmissible. The evidence obtained in such circumstances is evidence that is tainted, that is inadmissible and vitiated because it is obtained through violations of basic fundamental rights. During the trial itself, which started a few months later, I think the trial started in April 2002, the presiding judge interrupted Marwan Barghouti, who was explaining that he had always advocated peace. The presiding judge interrupted him, saying, "One who fights for peace doesn't turn people into bombs." When you're the presiding judge in a criminal court, you're supposed to at least pretend to be impartial or keep your opinion for yourself. At the end of the trial, of course, your duty is to declare whether the accused is guilty or innocent. But declaring him guilty of turning people into bombs before the trial actually had even begun was a clear violation of the presumption of innocence. I mentioned the media campaign before the verdict with leaks in the media. The defense team had troubles attending the trial itself. The trial was very much open to the media. Journalists from all around the world were invited. There were press stands outside of the courtroom for the prosecution to make press conferences, for instance. But Marwan Barghouti's team had trouble accessing on the first day, accessing the courtroom, and they had to enter through a side door because there were so many obstacles for them to access to the trial. Marwan Barghouti had also appointed 2 French lawyers to be part of his team of lawyers. They couldn't plead in court because there are only members of the Israeli bar are allowed to plead in court, but they were not even permitted to attend the trial. One of them, which is a quite famous lawyer in France, Gisèle Halimi, she passed away a few years ago, but she was a French ambassador and she was a member of the French Parliament also. When she arrived at Tel Aviv airport, she was detained for a couple of hours, interrogated about the Barghouti trial. She said that as a lawyer she didn't have a duty to respond to questions, but the police at the airport took her files, made photocopies of the file, which is a clear violation of the legal privilege of lawyers. So all this context make it impossible in light of international rules to consider that the conviction was made through the process of a fair trial. On the substance of the conviction itself, the prosecution called for 96 witnesses. Of the 96 witnesses, 63 were investigators. So none of them could be witnesses of anything that Marwan did or didn't do. 12 were victims of terrorist attacks. They could describe the terrorist attacks they had been victims of, but they couldn't say anything about Marwan's involvement. So this left only 21 witnesses that could possibly testify about his involvement, and not one of them testified that he had any involvement. And 12 of the 21 actually exonerated him explicitly. The notion that the trial made it possible to hear witnesses that comforted his guilt is not confirmed by the way the trial actually took place. The bottom line is that, as I said, the violations of international standards were such that I was not able to reach another conclusion, that it was not a fair trial under international standards.
Thank you, Simon.
Thank you.